So what the heck is going on with this DMCA for downloading Ubuntu? If you're not familiar, Ubuntu is a Linux distribution. Linux distributions are perfectly legal to download. I'm sure that there's some distribution out there that's not perfectly legal to download. Maybe Mac OS that's based on Unix of some kind. I don't know if it's based on Linux, but it's based on that platform. So yeah, you probably can't go just download Mac OS. But Ubuntu, you're allowed to download Ubuntu. So what happens when you get a DMCA takedown notice for downloading Ubuntu? What the heck could be going on there? This is Ars Technica reporting. Someone who looks like they're on Reddit, Nate60, received a DMCA infringement warning from Comcast. It says, "Dear Nate60, we have received a notification by a copyright owner or its authorized agent reporting an alleged infringement of one or more copyrighted works. They say the copyright owner has identified your IP address associated with your account at the time as the source of the infringing works. We remind you that use of our service in any manner that constitutes infringement of a copyrighted work is a violation of the DMCA policy. Please search all your devices for the files and delete them." What if you're allowed to have the file? It doesn't say that. It doesn't say anything about what to do if you are being falsely accused. For additional steps you may take, you may call us. For information regarding our policy, go here. Going to websites or using apps that offer unauthorized copyrighted work. This is an awfully accusatory DMCA notice. It doesn't say anything about counter notices or what happens when there's a false or misrepresented DMCA notice. It just says, please delete the files. And we have a termination policy. First of all, it is true. They have to have a termination policy. You have to have a policy that provides for the termination in appropriate circumstances of subscribers and account holders who are repeat infringers. So yeah, there's some basis for terminating an account holder after a certain number of strikes. And you may have seen our video about Cox Communication getting hit with, I think it was $10,000 per infringement of the music industry's music that its users were downloading via file sharing like BitTorrent when Cox didn't implement that termination policy. So that's why Comcast Xfinity has to send this notice. It says it's a peer-to-peer infringement of a file name called Ubuntu 2004.220 for the AMD platform, that it's via BitTorrent, and it's reported to be sent by OPSEC Online Anti-Piracy. Well, if you needed any more ammunition for why the DMCA is broken to argue in favor of overhauling the DMCA, well, you might want to see this next part of the story. OPSEC says the DMCA notice was spoofed to target the Ubuntu download. Yesterday, Torrent Freak reported that Reddit user Nate60 received a DMCA notice from Comcast declaring he'd breached copyright law by downloading and sharing a legal copy of Ubuntu. We have received a notification, etc. OPSEC Marketing Communications Manager Amanda Hershey says that the notice was malicious and sent to damage its reputation. OPSEC Security's DMCA notice sending program was spoofed on Wednesday by unknown parties across multiple streaming platforms. The content in question all appears to be Ubuntu Linux, the ISO. We have incontrovertible evidence that proves these DMCA notices were not perpetrated by or originated with OPSEC Security. And that's interesting because that is opening them up to be subpoenaed to testify as part of somebody's DMCA misrepresentation claim. Let's go over that now. So we've got 17 USC 512, which is the notice and takedown portion and the safe harbor portion of the DMCA. Real quick, the DMCA, the law, added this section to copyright. It gives service providers who host user content limitations on liability. The safe harbor refers to them being safe from lawsuits or safe from liability in a lawsuit if they follow these provisions. And one of them is to obey takedown notices. To be effective under this subsection, a notification of claimed infringement must be a written communication provided to the designated agent of a service provider that includes substantially the following: a physical or electronic signature of a person authorized to act on behalf of the owner of the exclusive right. So the owner or their attorney or an agent. Identification of the copyrighted work having been infringed. Identification of the material claimed to be infringing. Information sufficient to permit the service provider to contact the complaining party, such as address, telephone number, electronic mail address, etc. A statement that the complaining party has a good faith belief that the use of the material is not authorized by copyright, by the owner, by the law, by the agent, and a statement that the notification is accurate under penalty of perjury and that the complaining party is authorized to act on behalf of the owner. Where in there does any of that mean you can't spoof a DMCA takedown notice? It doesn't. Someone could just send a notice to a designated agent of a service provider and start claiming to be somebody else. If you gave it in your own name with your own phone number and your own address, sure, now I know who to sue. But if I made it in OPSEC's name and their address and their phone number, well, how does that get tied back to me in really any way? Maybe there could be an investigation as to what IP address that was sent from, but you could go through one or more VPNs or proxies or something could hide the true identity of the sender. There's nothing in this list that requires verification from the ISP or host, the service provider, to verify the identity of the sender. And the service provider gets their safe harbor because they obeyed the takedown notice, even though it was a false takedown notice. There is no requirement in here that the host verify the veracity of the takedown notice itself. In other words, shouldn't they have seen it's Ubuntu? Shouldn't some savvy IT professional or legal professional have looked at it and said, wait a second, I know Ubuntu isn't owned by OPSEC Security, or OPSEC Security isn't an agent of Ubuntu, or that even if they are, that Ubuntu is freely distributed and it isn't copyright infringement to distribute Ubuntu. So there's nothing. There's nothing preventing the spoofing of DMCA takedowns. There's nothing preventing the false sending of DMCA takedowns, except the really, really insignificant threat that a recipient like Nate60 will then hire a lawyer, file a lawsuit, and make a claim under 17 USC 512F here. Any person who knowingly materially misrepresents under this section that material or activity is infringing shall be liable for damages, including costs and attorney's fees incurred by the alleged infringer because a host relied on the misrepresentation. So we need ideas. We were talking about this in the supporters private stream. Our supporters on Lawful Masses get access to a private live stream on Sunday mornings at 9:30 Eastern. And one of our contributors, supporters, said, why don't we use public-private keys, have senders of DMCA takedown notices register with the Copyright Office and have some kind of verification as to who's sending the thing. And only people who register with the Copyright Office, only companies and things, could send DMCA takedown notices. They could sign those DMCA takedown notices with some kind of private key, and then the Copyright Office, or maybe at least in reaction in the future, a victim of a false claim could then go back and see whose private public key combination was used to sign the DMCA that was sent falsely. Something like that. Something that allows you to get back to the false sender of a spoofed DMCA. Now, I don't know anything about the truth or falsity of OPSEC's claim here. But Ms. Hershey does say that OPSEC's enforcement efforts are occasionally spoofed by a third party in an attempt to damage OPSEC's reputation. These attempts are easily identifiable and easily disproven. And what I'm curious about here is, did the DMCA actually get resolved, and Comcast now knows that that is not a strike on Nate60's Comcast account? Because here's the other thing that's bad about the DMCA. There's no adjudication of those DMCA takedown notices with respect to that disconnection or termination policy. If Comcast gets a notice that Nate has infringed, and then Nate does this and reveals to the world that it was false, what does Comcast do? Does Comcast have some sort of legal obligation to remove the strike from Nate's account? They should, but I'm not sure that they do. The DMCA does have this G section, G as in golf, 17 U.S.C. 512G, replacement or removal of disabled material. No service provider shall be liable for a claim based on their good faith disabling of access to material. So that's a DMCA takedown, but that's disabling of access to material. They didn't disable access to material. They just passed on a DMCA notice and put a strike on Nate60's account. But Nate could file a counter notification, and then the material would have to be restored. And so he has to provide a physical electronic signature. He has to identify the material. He has to state under penalty of perjury that the material was removed or disabled as a result of misidentification. He has to provide the name, address, telephone number, and a statement that he consents to the jurisdiction of a federal district court, all because somebody followed the DMCA takedown procedure and spoofed a DMCA takedown. It's not really a fair system in that sense. I challenge you to present any sort of fix to the system that doesn't do more damage, more harm than good, because that's been debated at length. And I actually mean to make a video about that. But there was a several-hour hearing before Congress back in September 30th of last year that I just haven't gotten around to editing yet. Congress discussed a lot of these things. Copyright owners and copyright victims discussed how to fix the system, and no one person had an answer, and there didn't seem to be one answer coming out of all the discussions. Copyright owners are upset that there's so much infringement and it's hard to send enough DMCA takedowns to be effective at removing the unauthorized copies. Copyright claim recipients are upset that they often receive false claims and they have to go through a burdensome process like this in order to overcome the false claims. So it's not really a great system. How would you solve it for both? Make it easier for photographers and musicians, et cetera, to take down infringing material while also preserving the rights of the people to make fair uses, not be subject to false claims like this one over Ubuntu. I don't know how you would fix that. Let me know your thoughts in the comments below. Thanks for watching. This channel would not exist without your support on patreon.com/ljfrench, sponsors.com/law, floatplane subscriptions, and YouTube memberships. Special thanks in the month of June to the following supporters: Joe Tyson, John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Torpedan, Brandyn Abel, ShadowTycho, Earthbound Star, RDHDragon, and PureMagma. And thank you to the rest of our supporters scrolling on the screen in front of you. I'm Leonard French, your favorite copyright attorney. I love you all. I'll see you in the videos. Have a great week. Bye. who needs lawnmowers.
I know. Can we just get some geese? Honk, 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 honk. Are you filming? So I just honked on your video.